With all of the lawsuits that have been filed against the Trump administration, I thought it would be interesting to just look at the different opportunities that the government has where they can appeal. So tonight we're going to be looking at when can Trump appeal adverse district court orders. Basically, what kind of procedural options does the Trump administration have to try to get things corrected? So that's what we're going to be talking about for a little bit in this video today. Judges today are issuing more TROs than Fauci issued mask orders. So that's a lot. Now, President Trump can still be the president. We still have 3 separate branches of government. It's just that the judicial branch can neutralize the executive branch for 4 years. So, okay, hopefully not. Hopefully that is not the case. So what are the times when the Trump administration can appeal? So first, with the temporary restraining orders, or TROs, those are generally not appealable. If an appeal is allowed, it could reach the Supreme Court in 1 to 3 weeks via this emergency application, which they've already filed several of those. But as we've seen what happened with Justice Roberts in the Supreme Court, where they didn't do anything, I think it's highly unlikely that they're going to be looking at an emergency application on a TRO, because those are generally not supposed to be appealable. Now, they are supposed to be able to be appealable if the temporary restraining order is actually something that's permanent, but the Supreme Court seems to not be wanting to view anything as being permanent, even if it basically is, because the district court said it was temporary. So that's one point when you can appeal. The second is after a preliminary injunction, you can appeal as of right, meaning it's not optional, you definitely can appeal, unlike a TRO where they can just say, nope, we're not going to do it. With a preliminary injunction, you have to be able to appeal. And that could reach the Supreme Court via an emergency stay in about 2 to 4 weeks. Or if you went through the full normal certiorari process, that could be 6 to 12 months, which would be terrible, but if it went that route, that's about how long that would take. And if you were going to appeal a final judgment, that appeal would go through the normal process, and you'd have a SCOTUS review via a cert petition. It may take 1 to 2 years from the district court judgment, so you're looking at like 2 to 5 years from when the initial lawsuit was filed. So appealing through the regular process after final judgment would be a terrible option, and hopefully we won't have anything going that far before we actually get some of these things fixed, because that would be terrible. When we recently had that TRO with the USAID case, and that went up and Justice Roberts on the Supreme Court stayed it, I got a little excited thinking, oh wow, they are actually going to issue a stay for real. And then that's when the court turned around after the weekend and said, basically, no, we're just going to leave the district court's TRO alone. So that's when we learned that basically the Supreme Court can ghost you like a bad Tinder date. Isn't that nice? I mean, I hope they at least had a discussion at the Supreme Court and tried to think through what they were doing. I mean, maybe their reasoning was, hey, there's only 75 cases that have been filed against Trump right now. We should at least wait to do anything until it's in the triple digits, right? And by the way, it is now, so now would be a good time for you guys to step in. The administration can file motions and requests for stays, which can significantly speed up the Supreme Court getting involved if they feel like it, and we have already seen a number of those. An emergency stay request is filed with the Court of Appeals, and if that's denied, then they can file an emergency application to the Supreme Court asking it to pause the lower court's ruling right away. With that USAID case that I was talking about, you might recall the government filed an emergency stay request with the DC Court of Appeals, which ignored them completely. And then they filed with the Supreme Court, which is when Justice Roberts issued that temporary stay basically over the weekend. And then the full court said, okay, we're just going to leave it alone. So they did try to get an emergency stay with the DC Court of Appeals in that case, and they were ignored, so they went to the Supreme Court. So the Supreme Court can act very quickly if they want to. It's just that they usually don't. And after that latest USAID case where they basically let the thing stand, it just seems like Chief Justice Roberts has the do not disturb sign on at the Supreme Court for a while, which is not helpful. Can you appeal a TRO or a temporary restraining order? Well, they typically only last about 14 days and they're usually not appealable. I think I mentioned that earlier. But there are some rare exceptions. If a TRO is acting more like a preliminary injunction, then that is something that should be able to be appealed through like an emergency stay application. Again, we've kind of been through that with that USAID case where it looked really permanent to me, and the dissent from the Supreme Court kind of thought it was permanent too, but he called it a TRO, the district court judge did, and I think that's how the majority saw it, so they just left it alone. So typically TROs, not appealable, they're going to stay in place the way that they are. With TROs, the administration can request a modification or dissolution in district court of the TRO. It's not going to happen because the judge just barely issued the TRO. So I can't imagine any of these are going to be, if you file the request to modify or dissolve, that the judge is going to say, you know what, the thing I did 5 minutes ago, you were right, I was totally wrong. So I thought I'd mention it. It is a procedural option, but I can't imagine that actually happening. Then they can file an emergency stay from an appellate court, so either the appeals court or the Supreme Court in some cases. In rare cases, when they feel like it's an emergency and they need an intervention, which they have done before. And if that goes that route, that could be from days to weeks with the Supreme Court. Looking at the Supreme Court right now with just Chief Justice Roberts and the way they acted with that USAID case, I would think that the odds of the Supreme Court granting an emergency application on one of these TROs is probably somewhere between winning the lottery and finding a unicorn. Somewhere in between there. Those are our odds right now. It just seems like Chief Justice Roberts and the court, they really want this to be at least at the preliminary injunction phase, which is just a little bit later. So based on that TRO, I almost feel like the government, you could file an emergency application to stay the TRO with the Supreme Court, or you could just put your briefs directly in the paper shredder, and I think the result will be about the same. Okay, I don't want you to feel bad. I do hope that the court will do something at this preliminary injunction phase, which is just going to be a few months later. I just think at the TRO stage, it seems like they just want to leave it alone. Appealing a preliminary injunction. Now, this is where I think, or where I hope, the Supreme Court is going to be willing to step in and stop some of this craziness. I've got my fingers crossed. So you can always appeal a preliminary injunction under 28 USA 1292 A1. I'm pretty sure that's right. And a standard appeal would go to the U.S. Court of Appeals. So whichever circuit you're in, you're going to go to that Court of Appeals. The administration can also request a stay pending the appeal. So asking the appeals court to stay the preliminary injunction from the district court while they have their appeal. And they can request expedited briefing, which when it's an urgent case, which all of these I think would be. So I would hope they would all be expedited. If it is denied, if the appeal is denied in the circuit court, they can file an emergency application to the United States Supreme Court. And I think typically they could issue some kind of relief in 2 to 4 weeks if they're going to be issuing relief at all. So this is definitely a longer time frame than a TRO trying to get an emergency application granted on one of those. But I think this is going to be the one that's more likely, because it just seems like the Roberts and the court's not going to want to look at it until it's at least to this stage. Oh, I do actually have some good news on this front, because we do have an appeals court that actually stayed a TRO from a district court. March 14th, so just, a week ago, the U.S. Court of Appeals for the Fourth Circuit, they stayed a nationwide preliminary injunction against the DEI executive orders. So, a district court nationwide preliminary injunction stopping the Trump administration's DEI orders, and the Fourth Circuit stayed that. Now they're I think a more liberal circuit court, so I was a little shocked when that happened, but very happy. So the Fourth Circuit staying an injunction against Trump. I'll take things I thought I'd never see for 500, Alex. So the main route is the certiorari petition, and that typically takes 2 to 4 years to have the whole thing resolved from when something's filed in the district court. So after he would lose in the district court, he would appeal to the appeals court. If he loses in the appeals court, he would then file a petition to have certiorari granted from the Supreme Court. And if granted, this is the normal route, but you're looking at like 2 to 4 years, which is terrible. In those kind of cases, the petition will be filed within 90 days of the appellate ruling. You'd probably see the decision to grant or deny cert in like 3 to 6 months. And then if granted, you'd have a full hearing and ruling in like 9 to 12 plus months. So, and if you're looking at like 2 to 4 years, that might be kind of, the best kind of timing, because if it's a really complex, nasty case, it can be even longer. Now, this is the president, and all these things are extremely important, so I would think everything would be expedited, but still, if they went the normal route, it would be terrible because it would take up most of his presidency. I'm going to mention there's also this other route, which is a certiorari before judgment, where you can fast track it to the Supreme Court, where basically the Supreme Court would take it and act like the district court and just hear the whole thing. That's never going to happen. So I'm just mentioning it so that you know that I knew about it, but I almost didn't put it on here because I thought that is not going to happen. The typical route to have the Supreme Court actually look at this is so long. I mean, there's no way you can have a president waiting that amount of time to have something decided because his whole presidency is over. That would be like, somebody agreeing with their wife, I promise I will start going to marriage counseling 3 years after our divorce is final. Like, it's just, what's the point? We do have emergency appeals and stays, which we have seen already. If an injunction blocks a major policy, the administration can seek emergency relief, which is what happened with the Fourth Circuit and those DEI policies where the district court issued the nationwide injunction. That was that route that the government went and actually got relief from the Fourth Circuit, where the appeals court, they can stay or pause the lower court ruling or order. The Supreme Court could also stay the application. The fastest SCOTUS intervention probably would be in the days to weeks time frame for one of these emergency applications. But like I said, I think the Supreme Court has kind of already indicated they're not going to be doing that in a TRO stage. It just seems like they are wanting to wait until it's a little bit more developed than that. I thought it would be helpful to look at one case study where we can see what really happened in a case similar to what's going on, and it actually involves President Trump in his first term with his travel ban. Now this timeline that I'm giving you is a simplified version. It was much more complex than that. I think there were 3 different executive orders, 3 different versions, because the administration was trying to fix it to address the court's concerns. But I was trying to simplify this so that you could at least see the time frame. But I think this is helpful because you can see what we might be looking at for some of these. So January in 2017 is when President Trump issued this executive order on the travel ban. February 2017, District Court issued a TRO. The DOJ then requested an emergency stay. The Ninth Circuit denied the stay, of course. They treated the TRO as a preliminary injunction. I said of course because the Ninth Circuit is one of the most liberal circuits out there. They're not as liberal as the DC Court of Appeals, but they're close. They're like Nancy Pelosi close. I'm guessing that the Ninth Circuit treats Trump's executive orders kind of like Nancy Pelosi treated the State of the Union. if you've seen that video. So anyway, the Ninth Circuit, they denied the stay. Then the Supreme Court granted a partial stay in June of 2017. So, 5 months later, allowing a limited enforcement. But then it was June of 2018 when the Supreme Court upheld the revised travel ban, which I think was the third executive order. And if you want to look it up, it is Trump v. Hawaii. But so we're looking at January 2017 to June 2018, a year and a half before we actually get a final decision on that travel ban in Trump's first term. So it was nice to see in that case that the Supreme Court decided that President Trump's first term could be at least 2.5 years long. So hopefully this term they will decide that it can be at least 3 years long, maybe 3.5. I really think with such a decisive victory from President Trump in the election, I really feel like the Supreme Court will see that as, okay, you know what, he has a mandate from the country. He needs to be able to implement his policies. I really think they will step in at that preliminary injunction phase and stop a lot of this nonsense. I think they should have done it with a lot of these at the TRO stage to slap down a lot of these so that we don't have the proliferation of lawsuits right and left. I wish they would have, but they didn't. But I hope they do the right thing. I'm crossing my fingers. I hope they will, and I think they will. But it's going to be several months, I think, before we will see something like that. But let's hope that happens. Okay, thank you for watching. Thanks for watching my headlines videos and my YouTube shorts. Have a fantastic weekend, and we'll see you next week.